Julie?
Morning. So this is on for several motions filed by the state. Motion for discovery-related issues, motion to eliminate to admit certified court documents, and motion to admit evidence of prior uncharged conduct of the defendant. Right?
All correct, Judge.
That's correct.
So state one count.
Particular order of motions, or go through all three one at a time? All right.
Whatever you want to do.
Judge, with respect to kind of the two more simplistic ones, the motion for certified documents, this is really just trying to avoid having to call someone in from the clerk's office to authenticate documents. If there is a certified court seal, we're asking for the admission of those documents for authentication purposes. Obviously, we would have a witness that would be present laying the foundation for those documents, but for ease of trial, and I don't see, unless you're trying to say that somehow the clerk's office certified seal is worth challenging on the stand, I don't see any reason why that motion shouldn't be granted. With respect to the motion for discovery, I anticipate that the defendant's going to argue that she didn't have the requisite intent to commit this crime, that she was doing so through some sort of necessity, which is a defense that's built into the statute for NRS 20359. If that's the case, the state is requesting discovery and documentation be provided as to what their alleged abuse is. This isn't a case that should be relitigating a family case. This is an abuse that they should be alleging from 10 years ago, 7 years ago, 5 years ago. All of those things have been brought up in the family court. They've been unsubstantiated. They're not relevant to her conduct in this particular case in October of 2018 and why she kidnapped the child. So the state's trying to get the information from the defense so we can ferret those issues out prior to trial so that we don't have constant objections to evidence. And that's really what the state's requesting with respect to the discovery.
Isn't that the one that, that's the issue, that there's a family court order keeping those things confidential, right?
I don't believe there's one keeping them confidential.
No.
I don't think it's under seal or anything.
No? Okay. I was thinking that there was.
There was an issue about the reports from Tennessee, I believe, that we were going to get, but I don't think there's anything from family court restricting.
I know the Tennessee orders that I've been trying to get with respect to the arrests that happened in Tennessee, they're saying those are confidential and it's been a process to try to obtain those documents. That's on the state side because I don't know if there's evidence in there that would be somewhat exculpatory, so I put that out to the court that we've been trying to get those police records from Tennessee. And so that's more.
Maybe that's what I'm confused about.
And we have provided the reports that we do have from Tennessee, I believe, to the state, or, oh, excuse me, apparently there's 3 reports. One we did, the other 2 we don't have.
Okay.
And so if that's the reports that they're alleging that is the basis for the conduct, then fine, but my concern is that we get into trial and they start bringing up all these issues that have been already figured out in family court that happened years ago, and I'm trying to avoid having a relitigation of the family issues. And I'd like to do it prior to trial so that we have a clean trial. And based on how the proceedings happen in family court, I anticipate if we don't do this in advance of trial, it will be the exact same thing that happens in family court.
I don't like family court.
But I practice here.
Why don't you guys address those 2?
Okay, Your Honor, in terms of the first one, in terms of authentication, in terms of a COR, I have no objection to anything that's been filed, duly filed in the state court. But in terms of relevance, I am not stipulating to that. She says she's going to lay a foundation. I'm not sure where some of this stuff is going to be applicable.
Granted as to authentication.
Yeah, so I have no issue with that. She can certainly lay a foundation trying to show the court relevance in time of trial. In terms of the second one, we are trying to get, I know she, that's not just for me, the 2 additional reports from Tennessee. There are 3. When we get those, I will certainly turn those over to Ms. Engler. but she seems to be trying to position this as though there's abuse way in the past. According to the letters we're getting from the child, the person we're all here to protect, this is ongoing. She's scared, she's being hurt, she doesn't want to be there. This is not something that stopped years ago. It is ongoing and going on to this moment. So I certainly do think that's relevant. I do think the court is going to need to hear from London directly. But in terms of any discovery we have from Tennessee, I'm more than happy to turn that over to counsel.
We'll make sure that she's put on house arrest.
As you know, the Supreme Court has
Okay, why don't you give me the statute?
I'm not putting up with any of the crap here today.
Don't unpack. That's not what today's hearing's for.
The likely result of that is you will be remanded into custody.
Counsel, your appearances for the record.
The court has a few comments before we begin.
Okay, sounds like I can grant that one.
Yeah, I have no problem with that.
Well, and Judge, the Tennessee stuff is fine, but my concern is exactly what he said regarding this is an ongoing abuse with regard to the minor child. Obviously, the minor child testified at grand jury. She's more than likely going to be testifying at the time of trial. They can certainly ask her questions about if there's been any type of abuse, but the problem is that, and the state is concerned, one, with the letters, because the state has concerns that those letters are forged. Two, the minor child herself testified that her feelings have only been recent within the last year and a half at the time of the grand jury. So if we're starting to go back 5-6 years, that's just not relevant to the conduct in this particular case. Because in order to have a defense of necessity in this case, it has to be an imminent necessity, not something that's been building up year after year after year of the defendant's perceived notions, because this is her whole deal. This is her whole creation of this notion that there's abuse, and there's just no documented evidence of it. And that's what I'm requesting. Where is the CPS documentation? Where is the letters that have been reported to police? Those are the types of evidence that is necessary for her to put forth this necessity defense. And that's what the state wants to have, and they don't want to be bombarded with all of this stuff at the time of trial.
If you have that, you got to turn it over.
And we have, Your Honor, the letters, I think they actually received before we do. I don't understand why they're saying they think they're forged. I have absolutely no problem with the court in camera taking these letters, London back. Did you write these? But nobody around. They were written for her. She's writing letters to the Supreme Court screaming for help. Even, I think, when was the last one she said?
She has 4 filed.
What was the last one she said? Answer my question.
Well, Judge, I specifically asked the minor child if she sent any letters while she was in Tennessee. She told me no, but there was a letter sent while she was in Tennessee. So,
Your Honor,
she sent that letter.
The easiest way to
It
put
sounds
it
like you guys are, you're trying to argue the merits of the case now.
No, she's trying to say these letters are forged. It's more of an evidentiary issue. And I'm saying the simplest way to do it, put them in front of London, in camera if necessary, with Your Honor. Did you write these? Yes, no.
So at this point, I mean, I can grant the motion and just require you to turn over anything that you have in that regard.
And I believe
if you haven't, turn it over.
No, and we will, Your Honor. I firmly believe in the discovery rules, but she's trying to, it seems to argue, or trying to argue that we can't go back in time, when she's trying a prior bad acts motion. I mean, you can't have both. And I do agree that if we start getting into the Supreme Court cases and the family court case, we will clog your court up for a month. I mean, that's how many cases are out there to try and get all that information out. I have absolutely no problem turning anything in my possession regarding London over to Ms. Engler. None. If I have it, it will be there by the end of this week, probably, if it's in my files.
That's easy. Let's do the third one.
All right, Your Honor, with respect to the state's prior bad act, I am trying to bring in a prior bad act, but Judge, this is from July of 2018. The one order that I'm trying to bring in, which is just 3 months prior to this incident. There are several non-propensity issues as to why this is relevant. It's relevant to show her common plan or scheme. She knew the parameters of what a pickup order was. She knew what she was not supposed to do, yet she did it anyways. This was an overarching plan that she had to commit this crime. She had her prior actions support the fact that she tried to take the child in July. The court ordered her to turn that child back over, and then she did it again 2 months later, this time by taking her out of the state to Tennessee, changing the child's hair, removing her braces, failing to enroll her in school. This was an overarching plan that didn't work the first time, and so she took further action again in October. It goes to her intent and her motive, her absence of mistake. It's the exact identical behavior. The conduct is not remote in time. The acts are essentially the same. It's clearly relevant to the state's case in chief. I have no problems believing the state could prove clear and convincing evidence, but if they feel that a hearing is appropriate, then the court can set it for an evidentiary hearing. The probative value of this evidence strongly outweighs any risk of unfair prejudice because she did the exact same conduct. She knew what the consequences were going to be, and yet she did it anyway. So the state believes that there are sufficient reasons for them to be able to admit this conduct. And if the court has concerns, they can certainly set it for hearing.
And Your Honor, I would like to have a Petrocelli hearing if she wants to try and put this evidence on. It's almost like she's trying to argue that this is one continuing offense. Certainly, I think the court needs to hear from London. A lot of these times, London is refusing to go. They even acknowledge that. She's telling the police when they show up, I'm terrified of this woman. I don't want to go. She hurts me. Okay, and that's part of the issue we're having with getting London back on time. It's not a common scheme or plan in that sense. It's more a matter of London not wanting to go back to Miss Rasmussen, who she's terrified of. I really think in order to start essentially untying this order, the court needs to hear from London. And I think we should have a Petrocelli hearing. I think she should testify.
It's probably safer for purposes of appeal to have Petrocelli hearing.
Yeah, and the state has no problem with that. But Judge, again, my concern with hearing from London, the Petrocelli hearing is about the prior conduct and whether or not the state has clear and convincing evidence that she committed this crime. and committed the prior pickup orders. We all know what the defendant says, the child's scared, the child's scared. And you know what? When the child's not with the defendant, she's not scared. What happens is she gets in the child's head, and then this becomes a spiral. And this kind of leads into an issue that we're going to be on before next week, where I filed a motion to revoke her bail because she violated the no contact order by doing computer FaceTime with the child, and there's evidence of that. And there's concerns that the child's feelings of fear are coming directly from the defendant.
Well, Your Honor, certainly we deny that. We will deal with the motion next week. I know the state is going to provide me the discovery and the evidence they say they have for that. But she can say one thing about London, I can say something else about London. Your Honor, let's get her into court and let Your Honor hear from London at the Petrocelli hearing. It certainly has to do...
How long are you guys going to need for that hearing?
I don't think that long.
Yeah.
Set it at 10 o'clock or 10:30 on a criminal calendar day?
That's fine.
How far out do you want to put it?
There we can do it for the hearing this week. Because she's on for the motion, she just mentioned we have a hearing for Your Honor.
Well, Judge, I have witnesses that wouldn't be the minor child, so...
I thought that might be a little quick, but I was just, for judicial economy, if we could do it all at once.
I mean, the trial's not till March, so...
You want to do it first couple weeks of December?
Second week of December,
Is that
probably.
far enough? Or?
I just have to, I mean, we can set it and then I'll confirm with my witnesses right away, to see their availability.
Do you like the 10th or 12th of December? Oh, we have another evidentiary hearing on the 12th, so maybe the 10th?
That should be fine.
December 10th? That's fine.
Set it at 10:30. Make sure that we're done with our criminal calendar before then.
For some reason, if my witness has a conflict, then I will let the court and defense counsel know right away.
Okay.
And I'll work with state too.
So the first two motions are granted. The third one, we're going to reserve for the Petrocelli hearing. Okay.
Thank you, Your Honor.
Thank you.
See you then. Thank you.
For the first motion, it's just in terms of authentication, not in this bill.
Great.
Thank you.
Page 11, state